What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. Happy Tuesday. Yeah. I think today's also a holiday. Hopefully you guys enjoyed your day off and yeah, I just blanked really hard on what I was going to say. I was sitting here thinking what I was going to say and I just completely forgot what I was going to say. So, you know what? I'm just going to stop while I'm not far behind. So we're going to continue our video from last night. And yeah, and as I said last night, we're going to have a few guests on tonight. You guys ready? Same people that were here last night so we could finish the video. Buttons. Here we go. What's up, everybody?
Buttons are hard. Words are hard. Everything's hard.
You really are a glutton for punishment, aren't you, honey?
You know what? Sometimes.
I'm just saying. You asked us here, we're here. But you okay? You need drugs or are you on drugs? Is that the issue? What's going on?
No. You know what? I probably could use some, but no, I'm not on any. Anyways.
Yeah. Thor's over there angry typing.
I know she's just blowing up her.
I type fast. I'm sorry. I've tried to silence my keyboards. I've tried to slow down, and I'm always told I'm angry typing. I'm sorry. I type fast.
Right.
Don't be jelly.
We didn't give everybody a TD dose last night.
Well, as I said a few minutes ago, about a minute ago, this is the part 2 of the video that we started last night. For anyone who was not here last night, it was Members Monday. I can summarize what happened last night in about 30 seconds. So here we go. So last night it was so you know what? I guess I should tell you what this case is about. So we have a defendant who was given a plea deal by a prosecutor. Then the prosecutor was changed out. I don't know if they actually told us why, but a new prosecutor came in and immediately pulled the plea deal. I don't know if they said he didn't like it or why he pulled it. I don't know if that came out either. But no, they pulled the plea deal. And this guy's looking at it, I don't know, I think he said 25 years, I think that he said he's looking at. And he was offered something, I don't know, the plea deal that he's mad that he lost was 6 years or 6 years.
I think it was like 6 years of community corrections or something like that.
Yeah.
Yeah.
So that's the plea deal that apparently he wanted, and it was taken from him because the prosecutor was swapped out. So now they're having a hearing, seeing if that was, if the prosecutor's allowed to do that. So, and we are in Judge Wolfe's court. So, yeah, we all love Judge Wolfe. So this is a good one. Last night we kind of got all the boring stuff out of the way. Tonight is when we're gonna have a little bit of drama, and we'll get to the end of it, so you can actually hear what happens.
Well, thank God.
Thank God that we're getting to the end of it?
No, thank God there's some drama tonight.
Well, I mean, yeah, you gotta eat your vegetables before you have your dessert, right?
Don't tell me how to live my life.
If you don't eat your meat, how can you have your pudding?
I'm pretty sure someone said that once. All right. Well, you guys ready to continue?
Oh, I'm certainly. Oh, look, Biggin just raided.
Oh yeah, and I am absolutely ready to go.
Awesome. Biggin just raided. Well, welcome, Biggin Raiders. Thank you so much for the raid, Biggin. I do appreciate it. And we have Miss Biggin just walked in. Hello, Mrs. Biggin. So I feel like I gotta. I'll just give the quick summary real quick again. So for all the Biggin Raiders that just came over, the case that we're going to watch part 2 of a case, and this case is about a defendant who was given a plea deal. He's looking at 25 years in prison. He was given a plea deal for 6 years of community correction, and before he was able to accept or deny it, the prosecutor was swapped out on his case, and the new prosecutor came in and just immediately pulled the deal. So now were in front of Judge Wolfe to see if the prosecutor was allowed to do that before the defendant was, able to actually accept it, because it sounds like he wanted to accept it. I think they actually point blank asked him, and he said, yeah, he would have accepted it. So that's where we're at right now. And so we're about halfway through this hearing. I know for everyone that just came in, you didn't really miss a lot last night except for what I just said. So you kind of got the background of what happened, got kind of the background of the people involved, and that was about it. So last night was kind of slow. So we're going to get into the good parts tonight. Okay. I think that's good. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
To take this offer, I would have got him in here quick because this offer was a sweetheart deal.
Did you try to get him in court to plead on the 6 to 8?
No, because he didn't want to enter the plea because he was still trying to figure out Clarksville.
When did he find out about Clarksville?
Clarksville had told us they weren't going to do a global deal.
I'm not asking that. When did he find out that he did have a global deal? When did he find that out?
He never had a global deal when I was representing that included Clarksville.
If he's testified today that Montgomery County has offered him 9 years community
Colin?
corrections and treatment, you're saying
I think they can't see the video. I can see it in StreamYard, but
I can't see it in StreamYard or YouTube.
All right. This happens every once in a while, so hold on. If I remove the video and just re-add it, it should fix the problem. Sorry, everybody. StreamYard does this from time to time.
Oh yeah, blame StreamYard.
you were about to blame Discord, don't lie.
Yeah.
Yeah, well.
All right, can we see it now?
Yeah, I think so.
Oh, what is that? That's my intro.
Hey, I'm saying.
You have charges right now.
Yes. Okay.
All right, can we see it?
I see it. I see it.
Can everyone see it that's watching on YouTube?
Yes, I'm checking on YouTube. Looks good.
I didn't check the timestamp from where we were. I'll just go here. I think this is close. Okay.
I don't know. I was wondering, he said something about Clarksville. I was wondering, when was that last train to Clarksville?
Yeah.
Oh my God, I was saying the same thing.
We are one.
It's the
We are
last
one.
train to Clarksville, and I'll meet you at the station.
Oh, I love it when
Sorry.
Mima sings.
I know. Mima, I love you.
I'm guessing that's where the line came from, the last train. Okay, let's just go.
Yeah.
In Clarksville. And if it was going to be a global settlement, he would not do it. And I understand your perspective, Mr. House. And here we are.
so. You say the nature of the offer was changed a little bit. How so? When was this changed to something else before Mr. Stevens made the big offer?
Whenever after we had discussions, well, I shouldn't say we, Mr. Arnold had discussions with his colleagues in Montgomery County that we couldn't get it all worked out globally. And there were yet again more charges pending, new charges pending in Clarksville, so that the offer changed just a little bit.
How so?
I think the length of it changed. It might have gone from 6 to 8, but that's where I was trying to double dip with the jail time.
Would that have been Mr. Arnold that upped it 6 to 8?
It was Mr. Arnold, yeah.
And when was that offer relayed?
I don't know the date, Mr. Walker. I don't know.
Okay. But until Mr. Stevens came in and made a much higher offer,
Right.
the pending offer was either 6 or 6 to 8, based on that tweak you referred to.
It was always, it was a pending offer that was out there if he wanted to do it, but he didn't want to do it because he didn't know for sure what was going to happen in Clarksville.
You're saying he didn't want to do it, or did he want to check with Montgomery County, like you indicated he probably should do?
He didn't want to enter a plea until he knew he didn't want to enter a plea here until he knew for sure what Clarksville was going to do to him based on a plea to these charges here. He didn't want to do it.
And if he's testified, his lawyers told him what they're going to do in Montgomery County, and he wanted to take that offer.
If he wanted to take this offer, I would have got him in here quick because this offer was a sweetheart deal.
Did you try to get him in court to plead on the 6 to 8?
No, because he didn't want to enter the plea because he was still trying to figure out Clarksville.
When did he find out about Clarksville?
Clarksville had told us they weren't going to do a global deal.
I'm not asking that. When did he find out that he did have a global deal? When did he find that out?
He never had a global deal when I was representing that included Clarksville.
If he's testified today that Montgomery County's offered him 9 years community corrections and treatment, you're saying he's wrong.
I'm saying that may be the case now, but when I was dealing with him, that was not the case.
Right? When did he get the 9 years community corrections and treatment in Montgomery County?
I don't know.
Okay. So what he's testified to could be correct.
Could be a lie. I don't know.
Right? So, I mean, are you saying your client's a liar?
Yes. Actually,
Okay.
I am.
All right. And so he's lying.
Oh, that's not good. You saying your client's a liar? Yes. Yes,
Right.
absolutely. That's exactly what I'm saying.
That was emphatic. Like,
Yeah.
yes.
Yes. Like, I've been trying to be nice about it, but yeah, if you're gonna ask me the question straight up, yeah. Cheshire Cat, thank you so much for the super chat. And Ruth asks questions late fee. Thank you so much, Cheshire. And hi, Ruth. Glad to see you.
About having this offer in Montgomery County.
I don't know if he's specifically lying about that. I know that it's part of his statements that he made were flat out lie. Yes.
And when did Mr. Stevens, I guess, revoke or make his offer?
That probably would have been late December, early January is my best recollection of it.
And could it have been late in January or early February of this year?
I sincerely don't know the specific day. It would have been the December, January timeframe. It would have been in there. Yeah.
All right. And if he's testified he had an understanding with Montgomery County and wanted to take the plea in January the 14th, do you know of any reason, based on anything you've received in writing, why he couldn't have pled?
There was no plea that was going to be entered on January 14th with Mr. Stevens.
Why not?
Not according to the offer that was, or in the neighborhood it was previously offered. I didn't have anything to enter unless it was, I don't know. Matter of fact, now that I think about it, January 14th, I hadn't actually met Mr. Stevens yet, because when I had to get the court date moved to go to the funeral, I was trying to figure out who am I going to have to talk to at the DA's office to make sure it's okay to get this court date moved and explain my situation. So I hadn't actually personally met Mr. Stevens at that point. We may have had some email exchange, I don't know, but I hadn't actually personally met Mr. Stevens prior to the 14th.
Had you talked to him prior to the 28th when it was reset?
Possibly. I possibly did.
All right. And did he tell you he wanted to go ahead and take the offer?
Who, Mr. Stevens? I don't understand your question.
No, not Mr. Stevens. Mr. Stevens wouldn't be taking an offer.
I
Did
know.
Mr. Hollis tell you he wanted to take the 6 to 8, the tweaked offer?
There was no offer available at that time
And why are you saying that?
because Mr. Arnold was gone.
And so when he left, the offer was gone?
Whenever I finally had a chance to talk to Mr. Stevens about the case, he explained to me, look, I'm not going to do anywhere near what Mr. Arnold was offering. I'm in this.
When was that?
neighborhood. For probably the 13th time. I don't know specifically. It was sometime in January.
Oh, this attorney's getting irritated. So this is the former defense attorney of the defendant. And he's like, I don't know. Stop asking me these questions that you already know the answer to. I've already answered them.
Wait, so he has a former defense attorney too?
That's what he said a few times. He said when I was
Right.
defending him, there was no offer.
Mm,
That's what he kept saying. So I'm guessing at the time when, he lost this offer, it was this guy was defending him. That's what it sounds like.
okay. Yeah. And well, it's not like everybody just swapped out, subbed out, like tapped out here. They're
I was
just
gonna
like,
say, is this like the tag team court?
right.
guess.
Like,
I
is there
don't
gonna be a
know.
different defendant later?
Yeah,
Like a twin
yes.
brother or something? And then next thing you know, the judge gets judged and is out, and the new comes in. I'm confused.
Yeah, Judge Judy's coming. in here or
Java, make it
something.
flow. I'd love that. I would love that.
Is there any kind of,
questions?
yeah. Oh, I'm sorry. I'm just curious. Is there any kind of precedent for this sort of, I don't know, what's he making, a motion or what?
Yeah, there's not. There really isn't. Because the prosecutor can make an offer and then take it back as quickly as making the offer. And just because the defendant's like, I want to wait until I see what this other court does before I accept or deny this, hoping for a global resolution, doesn't mean that the offer is still going to be there. So there's not really a precedent for this. Now, a lot of courts treat offers differently. Some judges force the prosecutors to make an offer. Like, you have to at least give them an offer before I'll set this to trial. Like, there are some courts that do that. And that's just what the judge does. And some, like, it doesn't matter. It's up to the prosecutor if you have an offer or not. So it really depends on how the judge handles his courtroom. So, I mean, really, from how I understand it, the prosecutor would be like, oh, if you plead guilty to, tripping me outside and giving me a wedgie, I'll set you free. And he's like, wait, what? Okay, I'm removing that offer. Like, the prosecutor can do that. It's just, yeah, you can, yeah. I mean, at least that's how I understand it. So I got
Yeah.
to make sure I say that I'm not an attorney. So I anyways, let me grab
Okay.
these super chats
Okay,
real
this
quick.
seems a bit odd.
Yeah. And some prosecutors will flat out say, here's the offer, but it expires, in 1 hour. So if you don't accept this offer within the hour, then, there's not going to be an offer and
Well,
we'll see you in trial like that.
that I get. That makes total sense. I mean, okay, I won't go on, but y'all know what I mean.
Yeah,
you're
it
good.
seems like a cluster.
No, this whole thing seems like a cluster. I mean, I understand both sides, but to me, the defendant doesn't really have anything to argue here. The offer was withdrawn. Sorry, man. Yeah, that's what I think.
But was he told it was withdrawn?
What's that?
Was he told it was withdrawn? Or does the new prosecutor just get up and say, yeah, I'm new, you blew it, I don't like what they offered you, so I'm just going to take over here and go, you ain't got shit?
Well, I think that's the whole thing, is that there wasn't like, nobody knew what was going on.
Yeah.
So.
And it's not like he failed to accept the order in a timely fashion. He was set for court where he was going to accept the offer, but he never got brought to court. And next thing he knew, there was a whole new attorney changing up the offer.
Yeah.
Okay,
so it's
I'm
not
sorry,
like he
y'all.
did anything wrong.
I don't mean to go on, but that just seems wrong.
I agree.
Yeah, I mean,
yeah.
I understand the defensive side. I do. Andy, thank you so much for the super chat. Don't say cat fee. Don't say cat fee. Okay, we won't say cat fee. What about cat pee? Can I say that?
Yes,
Jen, thank you so much.
approved.
Thank you. Approved. Jen, thank you for the
What's in your
the super
litter box?
chat. I like turtles. I like turtles too. Thank you so much, Jen. And Phil for the 5 gifted memberships. Thank you so much, Phil. Welcome to the 5 new members. That is awesome, Phil. Thank you. And Sparkle Poots. I feel like I've heard her voice recently. I think she was singing a little bit ago. To all of our vets in our chat and the rest of the world, a very sincere thank you for your service. Thank you, Sparkle Poots. And yes, thank you everybody out there. Okay. I actually brought up the Cheshire Card commercial, but we've been paused for a little bit, so I'll play it. I'll play it for the next time we pause.
Okay.
Most likely.
So whether it was before January 14th or after, you don't know.
Let me say it simply. I don't know the exact day, but there was no plea offer available on January 14th.
That's what I said. It was an offer, but it got tweaked and that it went to 6 to 8.
It was, that's my recollection of it, because I remember thinking, well, maybe we can double dip with the jail time to get it to 8, but really in effect, it would only be 6 in terms of community corrections. It was something, I remember thinking about that.
And as to whether,
Yeah, see, that would mean that we would be talking for 16 minutes and we've only played 4 minutes of this court. Now, we've played more than 4 minutes. So, nope, that's wrong. That's wrong. You should get better at math.
that offer was still on the table in January, you can't say for sure that it was or was not.
It was not. We didn't have the, what I've paraphrased or called the sweetheart deal was not available to us on January 14th.
All right, is the sweetheart deal the 6 community corrections or the 6 to 8?
Either one would have been the sweetheart deal.
All right, and you say the 6 to 8 was not on the table? Why do you say that?
Because I wasn't dealing with Mr. Arnold at the time. I was dealing with Mr. Stevens.
So Mr. Stevens talked about 6 to 8?
He never said 6 to 8, ever.
Well, you said the offer was tweaked to 6 to 8. Who made that?
Mr. Arnold tweaked it when we were trying to figure out globally what was going to go on with Clarksville.
And as far as whether or not on January the 14th, Mr. Hollis could have pled to either the 6 or the tweaked offer 6 to 8. You don't know if Mr. Stevens told you after that there was no offer.
I don't specifically remember when he told me that, but I know for a fact there's no way that offer was on the table on the 14th.
How? How do you know that?
Because I was dealing with Mr. Stevens at that point, and Mr. Stevens would not have gone from, okay, on the 14th, I would have let him plead to a 6 to 8 to suddenly, no, I want him to serve 25 years. That's beyond reasonable to expect that that's what happened. That's not what happened.
But when did he go to the 25?
Whenever I had my first meaningful discussion with him, he said, look, I want you to understand, I'm not going to be in the neighborhood. I think that was the word he used. I'm not going to be in the area or the neighborhood of what Mr. Arnold was and trying to resolve this case because I have a lot of knowledge of Mr. Hollis from his time in Clarksville in Montgomery County. And because of a variety of factors, that offer is not, I'm not even going to be in the realm of that offer. The offer is going to be 25.
But that's after the 14th of January, right?
I don't know. It may have been just before or just after the 14th. I don't know.
Well, did you go and talk to Mr. Hollis and tell him that the new offer was 25?
Correct. I did.
And you tell him the DA must have it in for him?
I told him the DA was being very aggressive because he had a
Okay, Sparkle. So you obviously see the judge. So in the top right, that little screen, you see the judge, and then to the bottom right of the top right corner, that's where the podium is. So that's the person questioning the guy on the bottom who's in the witness box. So if you're saying who that is, I'm not sure if that's the new defense attorney. I think that might be the new defense attorney. I'm not exactly sure. There's been like 4 people that have been up there. I'm kind of confused at this point on who's speaking.
Oh wait, I was looking at the guy in orange in the bottom screen. That's the defendant.
Yes, that's the defendant. He's in jail.
Right.
Now, if you're talking about
Wait.
the lady with blonde hair, that's probably the judge's clerk.
Yes.
No, what? Wait, what? What? What are y'all talking about? Who's in orange and where's the blonde?
I don't know. What are you asking?
I just answered
which
your
box?
question, Sparkle.
Which box are
Okay,
you asking about?
Okay, top left. I've got 3 screens. Top left, judge. Top right, who? Bottom middle, who?
That's the guy at the podium asking the questions. I just said that's either the new defense attorney or maybe that's the person arguing for. I think that's a new defense attorney. So I think that is.
So the guy to judge's left and top left is the same guy in bottom middle?
No, the guy in the bottom
No.
is is sitting in the witness box. He's sitting on the stand. Sorry, that's the stand. That's the guy he's asking the questions. That's the old defense attorney.
Oh, I'm sorry. Okay, I'm sorry.
You even saw part one
Well,
last
hell,
night,
they
Sparkle
look like
Pigs.
twins, sue me.
Stops.
How do I put it? He had a keen insight, or he had a lot of knowledge of Mr. Hollis and Mr. Hollis's charges, previous convictions, previous behavior in Montgomery County. And based on that, plus the nature of the charges he had here, which were similar in many ways, that he felt 25 years was a reasonable offer. And I explained to him, I understand your perspective, but in fairness to Mr. Hollis, you have to understand when he was thinking about Cheatham County, he was thinking about something in this range over here, maybe a split confinement, some community corrections versus 25 years in a penitentiary. That's a large difference. I'm going to have to spend some time with him to make him understand why you're being so aggressive.
But no doubt that was after January the 14th. Is that correct?
And I had that conversation with him.
Yes.
Probably, most likely.
Well, I mean, you testified earlier you hadn't talked to him before the 14th, so I mean, it would
Yeah,
have to be.
I mean, you're asking me to look at it specifically, and I'm saying it was in that same general time frame. Yes.
I'm just trying to ascertain if the offer was on the table on the 14th.
It was not on the table. If there was an offer that good on the table, I would have had one of my colleagues, hey, you need to go into this plea with Hollis on the 14th. I can't be there because I got to be out of town.
Well, you've testified it was tweaked to 6 to 8, but you've not said when that offer was taken off the table.
No, I can tell you 100% for sure, there was not an offer available to Mr. Hollis on the 14th of a 6 to 8 or a 6. It was not on the table at that time. I know it wasn't.
And is that based on conversations with the DA before the 14th?
I don't recall if it was based on that conversation or based on common sense that if he came at me with 25, he wasn't going to do a 6 to 8 on the 14th. It's one of the other.
Did you know that it was going to be 25 before the 14th?
I don't know. I've said this 17 different ways.
I think we've been down this. I've been patient with objections.
That's the same as asking answers.
Did you find out about the 25-year offer after you had met Mr. Hollis or before you had met him?
I met Mr. Hollis several times. When do you mean?
Right, on these charges, was it before you were appointed that you found out about the 25-year offer?
It was long after I was appointed. Yeah.
All right, and record indicates you were appointed when?
Oh, that's actually a really good question. I should have said that at the beginning of the video because that was in part one. It's a lot. Let's see. It was fleeing and looting in a stolen car with a felon. He is a felon. Fleeing and looting in a stolen car while drunk and possessing a firearm.
It was like all the things.
Yeah, it's like it was like 7 or 8 charges.
Yeah, and not his first time doing this.
Yeah,
too.
he's a felon, so he's not allowed to be in possession of a firearm. So he was in possession of a firearm while drunk, while driving, and he was running away from the cops. Yeah, there were a lot. It was 6 or 7 charges. It was a lot. So
Yeah.
that's why 25 years sounds about right. He got the whole bouquet. Yes, he absolutely did.
He
But yeah,
sure did.
I absolutely should have said that in the intro. So I do apologize for that, guys.
Probably a year and a half ago or so, something like that.
All right. And can you say whether you received that offer from Mr. Stevens before or after January the 14th of this year?
I don't know.
Okay. Did you have anything in your file that reflected that offer? I mean, was there a letter, an email, or?
think it was initially a phone call. We talked about it, and then he did a follow-up email. And in the email, he talked about what his sort of worst case scenario with the maximum, like if sort of the maximum exposure if Mr. Hollis was convicted of every last thing and the judge at sentencing ran as much as possible consecutive, sort of like the doomsday scenario.
And did your file have notations as to when the phone call was and the nature of the conversation?
I have to go back and review the file. I haven't even billed for this case. So
Is that something that if the court provides some time, can you look that up so we can ascertain when you had that call?
sure.
And can you get emails as to when you received emails from Mr. Stevens?
Yes.
All right. Your Honor, I would ask that he be allowed to supplement the record with that, because I think those are important dates in regard to the January the 14th of this year.
Your Honor, if I may briefly ask some questions, I don't think it's relevant. I don't think there was an open offer to where it would matter what happened after January.
Well, let me ask you this question. If there was an open offer, but it was never accepted formally by the defense and conveyed to the state, how is it a binding agreement anyway?
I agree that it's not.
The elements of contract law, if they're applicable to plea agreements, are number one, if there's an offer, and number two, there's an acceptance of that offer. It seems to me that we've been talking about something that isn't relevant, because I'll ask this question, Mr. Saul. Mr. Saul, did you ever convey to the state that your client was willing to accept and did accept the offer of 6 to 8 years or whatever that was?
No, sir.
No offer was accepted, then how can the state be forced to honor an agreement that was never entered into?
Well, according to the case law, Your Honor, the court can look at other factors such as, does there appear to be a retaliatory offer or a new offer or withdrawal of an offer based on some bias or prejudice or something that appears to be retaliatory. And there are a number of factors the court can look at in regard to whether they strictly enforce it as a contract that was not accepted, as opposed to something that was retaliation. And
Well, your client has never been convicted of anything. He has a pending case, and the ultimate remedy is he sets it for trial, and then he may get a better result than what this plea agreement is. It seems to me. I don't know. That is the difference between someone who enters a plea and then comes back and wants to redo the plea because of retaliation. The defendant is never required to accept the plea. He always has the remedy of being presumed to be innocent and go to the trial. And is that not different than the case law that you're citing?
the case law, you look also at the other factors, retaliation, fundamental fairness, those type things. That's the reason I've been trying to ask to allow Mr. Saul to supplement the record. Our position is he had not received anything revoking the offer. And on the January the 28th court date, he could have pled and taken the offer.
According to him.
According to him.
Your Honor, according to witness testimony that you've heard, speaking, including General Arnold, there was no offer. In fact, they previously tried to work this out. And when they talked to Clarksville, they said that we're familiar with his antics, nothing to do with me. I know their ADA said we're familiar with this. He's done the same thing again. We're not going to allow this. So it went back to square one, as General Arnold testified to. It's simply there was no offer to consider one way or the other. There's no retaliatory. I didn't have this case first. That was a first offer. This is not one where it's let's have a motion because you had a motion. I'm going to make a horrible offer to you. That was just the first offer, period.
And Your Honor, has been testimony this morning. Mr. Arnold couldn't recall all, but Mr. Saul said the offer was tweaked to 6 to 8. And when you say an offer is tweaked, that's an offer. And what I'm trying to show for the purpose of appellate purposes is that he could have entered that plea on January the 28th, because there's been no testimony other than Mr. Saul saying, well, common sense dictates he wasn't going to agree to that. There's been nothing filed in writing? There's nothing reflecting that offer was revoked or withdrawn.
Is there a written offer from the state to the defense?
Yes, Judge, there was an email. There was an email. We had a phone call about it and then we had an email
I'm talking about, was there a subsequent written offer from the state?
regarding the 25. Yes, sir. There
No,
was-
not the 25. I'm talking about the one that Mr. Locker wants to try to enforce.
No, there wasn't.
So there
We were
was
having
already-
verbal discussions going back and forth, Judge, and
There were verbal discussions, but no written offer.
no written offer, and it was always contingent or hung up on Mr. Hollis's desire to make sure whatever we did here didn't adversely affect what was going on in Clarksville. And if I may add, at some point during this process, Mr. Arnold and I, neither one of us were aware of the fact that he also had new felony charges pending in general sessions. And then we learned of that and we thought, uh-oh. And it was around that time that Clarksville said, we're not willing to do anything favorable because of, he picked up new charges in Cheatham and new charges in Montgomery County, as well as having an open violation. Well, he was on probation. I think it was a 9-year sentence in Montgomery County. So the Montgomery County DA's office wasn't willing to do anything that could possibly be considered favorable to Mr. Hollis.
Well, at that time,
Yeah.
and whether that's different now, you don't
Maybe
know.
it's different now. I don't know.
And whether the offer is in writing, you did have an offer of 6 years community corrections, is that correct?
That was rejected by Mr. Hollis because he wanted to see what was going to happen in Clarksville.
Now, you testified earlier that when y'all discussed that, and he said he wanted to check on Clarksville, you said you told him that would be a wise thing to do.
I told him that I understood if he wanted to see how it would affect it, I would do what I could. But I also told him, regardless of what I learned, his offer in Cheatham was, in terms of in a vacuum, the Cheatham County offer was never going to be better than what he got at that time. It was never going to be.
This is Judge Wolfe, and he is in Tennessee. I think this is the only court that I have in Tennessee. But yeah, Judge Wolfe, Tennessee.
Better than that, in my opinion.
I understand, but you said he rejected it.
He
And
did.
actually, what he did was talk to you and say he wanted to check on Montgomery County, and you told him.
Yeah, that's a contingency.
Fact of the matter is, he never accepted it.
Correct.
So there was. in my
At that
opinion,
time.
In the whole time that I represented
I
Mr.
sustain the
Hollis,
objection as to the relevance.
Yes, Your Honor.
Mogan isn't Tennessee. Mogan's either, is Mogan Minnesota?
No, she's
Is it-
Wisconsin.
Wisconsin, okay.
Yeah.
She's the one that's in like super northern Wisconsin. That's
Yeah,
basically
she's like
Minnesota, right?
close to Minnesota. Yeah.
All right. Yeah. There we go. Thanks for the assist.
You're welcome.
And was that original offer, once you found out some things about his past, was it tweaked by Mr. Arnold to 6 to 8 years?
I have a memory of it, of there being some kind of a tweak to it. And I don't know if it was specifically related to that or if it was, there was some issue and about the length of the sentence. And I remember thinking, well, Mr. Arnold might let me double dip with the jail time and shave that off. So we end up back at the 6. And these were just discussions going back and forth, trying to figure out what we could do. But at no time did we have a plea agreement where Mr. Hollis was going to enter a plea here in Cheatham County, where he wanted to enter a plea here in Cheatham County that was rejected by us. It was always Mr. Hollis wanting to see what was going to happen in Clarksville.
And you did testify the offer was tweaked to 6 to 8.
Objection as to.
Yes.
Sustain.
Yes, at some point there was some adjustment.
Question, I sustain the objection.
Well, Your Honor, I'm asking based on Your Honor's question about whether there was an offer.
And you've asked that question about 5 times today about whether it was tweaked, so I sustain it as being asked and answered.
All right. So
it's-
other than those two offers, was anything else made?
I mean, I
You've
feel
asked
like
that
he's
question about 5 times.
I think he's only asked 4 or 5 questions. He just keeps going in circles.
It's just the same one.
Yeah. It's like we get it. Yeah, he had an offer at one time, then he didn't have an offer. But is that what you're saying? Yeah, that's what I'm saying.
Yeah.
So he did
Yeah.
have an offer at one time, yes. And then he didn't have one. Yes.
Yes.
But when did he not have one? Like what?
Okay, but it changed, right?
Yeah, but
The
it
original
changed.
offer then
Tweaked.
changed though, right? You tweaked it, right?
Right? Tweaking.
Okay.
Tweaker.
Okay, yeah. But
Tweak.
but the original order,
Twerk.
the original order was tweaked while you twerked with the tweak.
Yes. I think
Okay.
that was a direct comment too. So you nailed that one.
I don't know why, but
Right
now
quote.
I need the narwhal twerking. Java, get on it.
Oh dear.
Any other offers made?
I don't recall any other offers made by.
And then you go up maybe like to 10 or 12 or something, anything of that nature.
It's possible. It's possible that I was trying to. It's possible that through a
Okay.
negotiation process, I imagine that's possible there.
And notes in your file and emails will reflect as to when Mr. Stevens essentially took that offer off the table.
Exactly.
That's all the questions I have.
Redirect, Mr. Stevens.
I'll make it very brief, Your Honor. I think we've been around quite a bit.
It's your document.
I'll make it very brief, Mr. Saul. Going back to contract law, was there ever an offer and an acceptance in this case?
No, there's always. I'm not a contract attorney, but there was always a contingency attached to it.
Were there negotiations with yourself and General Arnold,
Absolutely.
but there was no meeting of the minds that would effectuate a contract that had to be enforced?
No, it was always, in summary, it was always, yeah, but let me check on this other thing.
And in fact, your testimony was that Mr. Hollis himself was not willing to enter this until he knew what he was going to do in Clarksville.
Exactly.
And before you came off the case, nothing was ever agreed upon in Clarksville.
Now, as far as I knew that.
Before you came off the case,
Before I came off, I was not aware of anything that Clarksville was going to do in terms of running their disposition concurrent to Cheatham.
if you had had an offer with 6 or 8, whatever it is, would you have entered it?
Absolutely.
That's all that I have.
All right, I swear to God, if he comes up here and does a redirect asking the exact same questions, oh man. Oh man. Why do I feel like that's about to happen?
Maybe he'll just twerk in his briefs for us.
Maybe. But I don't need to see that either though. So anyways, let's actually catch up on these super chats real quick. Jedi for 22 months. Thank you, Jedi. I appreciate that. Grammar School for 5 months. Thank you, Grammar School. And then Jedi with the thank you, Jedi, for the super chat. Grammar late fee. Hashtag Cheshire card. Thank you, Jedi. Cheshire card. Andy, thank you for the super chat. Cheshire Cat's tweaking feed paid by Cheshire Cat. Yeah. And then speak of the devil, Cheshire Cat. Fee for the squirrel twerk added to the flow chart. Thank you. Thank you, Cheshire Cat. And every time I see this name, I always want to say Michelle Dennis. Like, no, stop it. And I think I've even said that before, but for whatever reason, when I try to read your name really quickly, Michael, the first thing that comes in my head is Michelle. It's like, no, that's why I need to read before I just say things. But Michael Dennis, thank you so much for the 16 months. I appreciate it. Words are hard. You know what? This is actually a good time for anyone who has not seen this. Hold on. Let me do. Since Cheshire Cat just sent a super chat. This always takes me a second. I'm not good at this. All right, so share. Gonna full screen this guy.
I could just stick it in the Google Drive so you can grab it.
Yeah, I actually meant to.
Hey, if we're not watching people twerk, I don't want to hear about anybody sticking anything anywhere.
I think that would actually be worse. Anyways, let's go. This is you know what? I'm not even going to spoil it for people who have not seen this. You're in for a treat.
We spoil our pets. Fancy beds, family time, toys, and even what we put in our litter box. When it comes time to pay, we've got you covered. Cheshire Card. What's in your litter box?
That's
I
good.
love that so much.
That's good. That's good. It's yeah. Anyways, that was awesome. Thank you guys for putting that together. Why is my screen? Oh, I gotta stop sharing. Say my screen is glitching. Anyways, I got nothing. Let's keep going. Still makes it better make you laugh. Better. It better. Serena and Jedi worked hard on that. Okay, let's go. There's no sound yet. He's not at the podium. Now he's walking up.
May I approach?
You may.
If you would look at the top paragraph. And does that reflect the date that Mr. Stevens said he relayed the 25-year offer to you?
Yeah, the opening paragraph is, Jake, per your request, I'm providing a written offer of settlement. Please note that this will be very similar to the one previously sent to Attorney Scott Saul on January 27th, 2025.
All right. And so, I mean, based on that, you don't doubt that you found out about the 25 until after the 14th of January.
Yeah, most likely it was based on that. It was after that. I know there was a phone call from Mr. Stevens where we talked about the case, and then he said, let me send you an email that completely summarizes the offer, so you have a written offer.
Right.
Now, when that phone call happened, I don't know, it may have been within a day or two.
But you could check your file.
Yeah, I can check the file.
And we know, at least as far as writing, it was the 27th that he said he conveyed the 25-year offer to you.
Yeah, I mean, according to that email, yeah. To
Well, I
January
mean,
27th.
you don't think General Stevens would state that wrong in an email to me, do you?
No, what I just said is, according to the email, it said January 27th.
All right. And you don't have any reason to doubt that.
No.
All right. That's all the questions I have, Joe.
No redirect, Your Honor. That's all.
Mr. Swillies and stuff like that.
Thank you, Judge.
State calls Sergeant Matt Farrell.
Sir, please state and spell your name for the record.
Matthew Farrell. Matthew spelled Matthew, Farrell, Ferrell.
Where are you employed?
Clarksville Police Department,
How long have you been employed there?
going on 16 years,
What is your current role?
sergeant,
What was your role in or about September 22nd of 2021?
narcotics agent.
Were you a drug agent?
Yes, drug agent.
Do you recognize the individual seated here today?
Yes,
Who is that?
Billy Hollis.
Your Honor, for the record, he's identified the defendant.
He has identified the defendant.
Do you ever recall an incident on or around the September 22nd date, 2021 involving Mr. Hollis?
Yes,
Where was that at?
that would have been at, well, several places, Big Lots, Shell, and also Oak Haven Motel.
Now, you testified you were a drug agent. Were you doing a drug investigation that day?
Yes.
What led you to have an incident with Mr. Hollis?
We were actually at the Big Lots. It's on Riverside. I can't remember the numerics off the top of my head. We were observing, just doing normal surveillance in that area for high drug areas. We observed one vehicle, I believe it was a gray Honda, pull up as an agent put out that was on surveillance, do a hand-to-hand with another vehicle. Those vehicles then cross Riverside to Shell, which is directly across the street.
Hand to hand, what does that mean, just generally speaking for the record?
You would
Drug
see-
transaction?
Yeah, drug transaction, yes,
Okay.
sir.
And did you ever see who got into that car? Did you have a way to where you could see who got into that car at the Shell gas station?
Yes, me and several agents did.
Who was it?
Billy Hollis.
The man sitting here today at the defense table?
Yep.
And what did you do after that, after seeing him get in the car?
Both vehicles then left the parking lot of the Shell gas station. We had several UC undercover vehicles in the area conducting that surveillance. They followed that vehicle and the one that was operated by Mr. Hollis. There, we pulled all the way around. We went up, took a left up Boot Hill and went up Fort Campbell Boulevard, Providence, north. From there, we ran Mr. Hollis's information, determined he had a suspended license. There, I attempted to conduct a traffic stop at the Oak Haven Motel parking.
Said Boot Hill. Is that like the hill on
I'm
Fort
sorry,
Campbell Boulevard?
Yeah, it's off of Riverside, turn left.
Captain Science, thank you so much for becoming a member. I do appreciate it. Welcome to the family. Also, why I don't understand the relevance to the officer testifying right now. Like they're not really talking about the case in chief. They're talking about the plea deal. What does he have to do with it? I don't understand what's going on right now.
It could have something to do with the prosecutor yesterday who brought up this guy being a multiple repeat probation violation offender. So this guy just talking about the general idea of who this guy is and why he doesn't deserve the better plea deal, just to prove something.
Yeah, okay.
Maybe.
Okay.
I don't know. Long shot, but it's a thought.
Yeah, no, that might be what it is. I mean, I guess the judge is going to decide whether or not he's going to, force the prosecution to give him this plea deal back. Maybe that makes a little bit of sense.
Going north, going up Boot Hill, that's Providence. Providence then turns into Fort Campbell Boulevard.
That'll take you to Fort Campbell if you kept going that way.
We were running his information based on the vehicle to see who was in there. Once we realized he had a suspended driver's license, that was no probable cause to make a traffic stop.
Did you ever try to make a stop on him?
Yes.
And tell me about that. What happened?
He pulled the vehicle operated by Mr. Hollis, pulled into the Oak Haven parking lot. That's a motel off of Fort Campbell Boulevard. When he pulled into the parking stall, I initiated my emergency lights and sirens. From there, the vehicle backed up and took off.
So did Mr. Hollis stop for the lawful command to stop?
Nope.
Okay. This area, Boot Hill and Fort Campbell Boulevard, is that heavily trafficked? Is there a lot of people there usually?
Yes.
What happened to the other traffic on the road when Mr. Hollis was told to stop?
Several vehicles had to stop as he entered back onto Fort Campbell Boulevard at a high rate of speed.
Would he have hit them otherwise?
Yes.
Did he ever pull over for you that day?
No.
Okay. Now, he's here today on a motion for furlough. Based on your experience with him, do you think he'd be a good candidate to trust to release out and hope that he would come back to jail or court for his appearances?
Absolutely not.
That's all that I have. Thank you.
Rocket, you may cross-examine.
No question.
Yeah, this guy's
Thank you.
getting no love.
Detective, you may sit down, officer. Stevens and McCoy, next witness.
That's state's proof, Your Honor.
State has rested their proof. Does defense have any rebuttal proof?
Yeah, if you can call Mr. Saul back, there's a brief.
So I'll remind you, you remain under oath.
He really just called him back up. I don't know what he's trying to gain from this attorney, but all right.
Wait, he's going
Let's go.
back to the attorney again?
Yeah.
Let me guess what his question's going to be. Was there a plea deal?
It was her plea deal.
What? Did you ever tweak it?
You didn't twerk it
man.
though, did you?
No, just tweaked. Oh, we just lost Sparkle Boots.
Yeah, she sends her apologies. She was feeling unwell.
Oh, okay. Well, hopefully she
So.
feels better soon.
Yeah.
In regard to those court dates, are you confident it was January the 14th that you were not in court for your brother's death, or could it have been the 28th?
No, he died on December 31st and his funeral was on January 15th. I was
Okay.
traveling on the 14th.
Okay.
I can provide an obituary supplemental to the record if you like.
No, that's fine. And the 28th, you were not there in court. January 28th.
I don't know. I already asked and answered that.
You
I don't-
did? Okay.
Yeah.
So you don't recall if you were there?
I don't recall. I know that it was reset. I don't know if I was here that day or if it got reset again without me being here, or if there was an issue.
Okay, I don't know if you guys caught that. This is hilarious. The witness just said, "I've already been asked and I answered that." Like he just said the objection from the prosecutor. Like, hey, come on, prosecutor, object, asked and answered.
I
Like, oh,
caught
you did?
that.
Oh,
Yeah.
okay.
And wait, who died?
The attorney's brother. So this guy, the guy who's being
Oh,
questioned,
okay.
his brother passed away.
Gotcha.
So that's why he missed court on
Okay.
the 14th.
With his transport. I know there were at least one or two occasions when I went to visit him at the jail. And I thought he was here, but he had been moved to Clarksville for the sake of his Clarksville cases. So I don't know if it was one of those times. Honestly, I don't know.
And if there's a letter in the court file where he wrote saying he thought he had court on the 28th, and the clerk told him that it was reset to June, you don't argue with that. I mean,
I don't know.
okay. May I approach?
You may.
Ask you, do you recognize that?
I mean, it's in my handwriting. Yes.
All right. So at some point in time after the 6-year offer, you gave an offer to Mr. Hollis reflecting what?
I don't know when this offer was made to Mr. Hollis.
I didn't ask.
You just asked
the
me.
date.
You just asked me when. I just told you I don't know when.
All right. You testified earlier, you didn't even talk to him until the 14th. So I'm just,
What?
logic would,
Okay. This was an offer that was made at some point related to pleading to a DUI first, felony evading, theft, possession of a weapon, and paraphernalia. All to serve concurrently, a global settlement of 4 years at 30% to serve, all concurrent to whatever Montgomery County might give them. This was not anything that was this was very early in the process. Because I remember when he didn't want to do this, I thought I may have a problem with Mr. Hollis because he's been around the block and he just rejected a very reasonable offer. I remember this was very early in the process.
well, would it have been before or after the 6 years community corrections?
Before.
And how do you know that?
Because I remember the 4 at 30 thinking that that was a gift and he rejected it. And I remember thinking how foolish that was.
Okay. But you didn't testify to this offer before.
Because you didn't show me this until just now.
That you didn't remember that there had been
I didn't remember this. I
an
read it.
offer?
I remember thinking he was foolish for doing that. There were so many offers that went back and forth on this.
Yeah, I moved this as an exhibit.
Michael,
Would your file help clarify when these offers were actually made and when they were revoked?
There was some notes in there about it. I remember that offer because I remember when I wrote it out, he would be foolish not to take that because I was shocked at how good the offer was. Because I knew Montgomery County was going to give him some time, most likely.
Yeah, and I'm gonna make the other offer a part of that. This is a corrected.
you may.
So I guess maybe if you could refer to your file, it might help you as far as when the offers were made, what the offers were, when they were revoked.
One thing my file will not is my distinct memory that Mr. Hollis never fully accepted anything.
Right, because by fully accepting, you enter the plea in court.
He never accepted anything.
So you're saying every offer you made, he rejected?
He either rejected it outright or he rejected it because he wanted to see what Clarksville was going to do.
And again, not to rehash, but you told him that'd be a wise thing to do, to check on Clarksville.
Graham,
Let me rephrase it. You're not saying he outright rejected every offer.
What I just said is he either outright rejected the offers or he would hang a contingency on his acceptance of it based on Clarksville.
And would notations and emails and notes of phone calls in your file better help establish what was made, what was rejected, what was revoked, times were
Hey, what's up, IA? How are you doing tonight? It's been a little bit. Hopefully you're well, my friend. Hopefully you're well.
received, that type thing?
I doubt that I made a notation of every detail of every conversation with Mr. Arnold, Mr. Stevens, and Mr. Hollis. I do know that he never accepted any offer fully.
And so again, would your file help you?
Objection asked.
My file wouldn't help me because I have the distinct memory of thinking the whole time that Mr. Hollis was going to find out what my tax instructor would tell us, that pigs get fat and hogs get slaughtered.
I understand Mr. Saul wants to say
I'm not
whatever he
going to
wants to say.
require Mr. Saul to open his file and bring forth anything. He has testified under oath as an officer of the court that this defendant never accepted any of the offers. Now, the fact of the matter is that there is no written offer from the state that has been produced to me. There's some handwritten notes here, but that's oftentimes done in negotiation. But there is no written offer, printed offer from the state of Tennessee to Mr. Hollis, setting forth what they were offering. Nor is there any evidence that he accepted any of those offers. What I have is that Mr. Hollis is saying he was willing to accept an offer, and then the offer was withdrawn and substituted. But there was never any official offer that was accepted by the client. So I'm not of the opinion that the defendant is entitled to open up Mr. Saul's file to try to make something into the situation. So I'm not going to require him to open his file and go back and do that.
Well, just for the record, Your Honor is not going to allow Mr. Saul to provide notations or emails as to when offers were revoked or pulled.
Correct.
Nothing further, Your Honor.
Step down, Mr. Saul. This case is here before this court on two motions, one of them being the motion to enforce the original offer.
All right, we're getting into the judge's decision now. This is oh man,
Has he made heads or tails of this?
I think he's just done. He's like right there. He's like, we're not gonna go through this entire file. You've already had your chance to talk to him.
Right.
Why?
Mm-hmm.
And then he's like, oh, so for the record, you're not gonna let him answer A, B, and C. No.
No.
Okay.
Well, then I'm done.
That's right. I'm going to
go
take
sit-
my ball and go home.
I was just going to
Yeah.
say, I'm taking my briefs and going home.
All right, let's see what Judge Wolfe says.
Was allegedly made in this case, and this court finds that there was never any official offer that was accepted by the defendant that was made by Mr. Arnold for 6 to 8 years or 6 years or whatever. There was never any offer. There's no proof of any such offer that was accepted by this defendant. That the credible proof that's before the court is that there was continuing negotiations, that Mr. Hollis was concerned about the charges that were pending in Montgomery County, and that for that reason, he was not willing to accept the offer and enter a plea until he knew for sure what was, and it's logical that that would be the case. Once Mr. Arnold left, the court finds that a new assistant district attorney was assigned to the case. It has been alleged that there was some malfeasance in his withdrawing the offer and offering a more substantial. First of all, the court finds that Mr. Hollis is not required to accept this 25-year offer. He is free to plead not guilty and go to trial as any other defendant who receives an offer that they don't accept, that they don't find palatable. And therefore, this court does not find that there is any basis upon which that the court can force the state to offer him an offer that he is unwilling to accept. Mr. Hollis is facing a driving under the influence charge, evading with a risk of death involved, reckless endangerment, failure to obey traffic control device, speeding, theft of property, $10,000 to $60,000, possession of a handgun under the influence ×2, which means 2 different counts, possession of burglary tools, being a felon in the possession of a weapon ×6, simple possession, possession of paraphernalia, aggravated assault with fear ×4, prohibited weapons with explosives ×3, driving on revoked license, second offense, evading arrest, resisting, repress, halt, arrest, or search. Those are the charges in this one case. The affidavit of complaint, and I'm reading this into the record to show why a new assistant taking over a file would review the file and make a determination of whether or not they were willing to stand by the prior offer or whether there was a basis for making a different offer. This affidavit is by Sergeant Mealer of the Ashland City Police Department.
Is it your birthday, Ruth? Happy birthday. Happy birthday, Ruth. And thank you for the super chat, I appreciate it. But Ruth, thank you very much for spending part of your evening with us. I appreciate it. It makes me happy when people spend a little bit of their birthday time with me. And I don't know why. I know I'm being selfish and thinking about me, but I don't know why. It gives me a warm, fuzzy feeling. Like it just makes me feel a little special. So Ruth, but happy birthday and thank you. And yeah, hopefully you had a great day today.
Happy birthday, Ruth.
He states that on the date in question, August the 14th of 2023, I was stationary on 41A at Boat Factory when I clocked a white van eastbound at 68 miles per hour in a posted 45 mile per hour zone. I attempted to stop the vehicle and it fled on I-24 eastbound, running the red light at Highway 41 and Highway 49. We continued our pursuit for several miles. During the pursuit, the driver, Billy Hollis Jr., attempted to strike law enforcement vehicles a total of 4 times during the pursuit. His vehicle was ultimately spiked and came to a stop on Clarksville Pike at Manchester Drive, where he and his passenger, Tasha Perry, fled on foot. Both subjects were taken into custody. The vehicle's tag did not match the vehicle, and VIN number came back stolen out of Oak Grove, Kentucky. Inside the vehicle was approximately 0.5 grams suspected marijuana, miscellaneous paraphernalia, 2 handguns, 3 shotguns, one of which had a barrel shorter than 16 inches, 3 explosive devices or grenades. Driver's license check on the driver revealed he is suspended as of 4/12/2021 out of Montgomery County for failure to pay costs, fines, taxes on criminal offense. Both occupants are convicted felons. Once we caught Mr. Hollis, he refused to identify himself to law enforcement. Mr. Hollis had an odor of alcoholic beverage coming from his breath and person, as well as the extensive drug paraphernalia. He was asked to conduct standardized field sobriety tests, and he refused. He also refused implied consent. Now, I read that into the record to make it clear that a different assistant district attorney would have the right to review that record, and that
Yeah, that's some record right there. Yeah. Iron Otter, thank you so much for the super chat. I just wanted to thank you and your chat for the awesome welcome I always receive here. It's like I'm important and stuff. LOL. Congratulations on a great channel and chat, sir, and happy birthday. Happy birthday, Ruth. And Iron Otter, no, you're one of the first people that I've ever met online, so I appreciate it. So yeah, you're always welcome here. And thanks again for the super chat.
Any proof, which there is none in this record, of an inappropriate or a motive to somehow personal vendetta against Mr. Hollis. This is simply a fact where assistant district attorneys changed. There was never an accepted offer that had been made and accepted by the defense. And as a result of that, the new assistant district attorney looked at the charges, as this court has looked at the charges, and made a decision that he felt that the record and the charges, if convicted, would result in a higher sentence. The proof is clear, in this court's opinion, that the credible proof is that there were discussions, there were offers made that were never accepted because of these other pending charges in Montgomery County. And as a result of that, there was never a firm plea agreement that was on the table, and that upon the change of assistant district attorneys, that there was a valid and ascertainable reason for the change in the plea agreement and a plea offer rather, and that there was no proof or evidence in this court of any malfeasance on the part of the district attorney or any reason why that would have been revoked. As a result of that, the court denies the motion that the defendant has filed to enforce the original plea offer, because this court does not find there was a verifiable firm plea offer ever made during the negotiations. Second, the court considered his request for a, and I would again finalize by saying that on that issue, Mr. Hollis is not required to accept that 25-year offer. He is free to go to trial.
Hey, what's up, Ed? Translation, enjoy your 25 years. I don't think he's been to trial yet. I honestly don't. I think that he's still waiting.
Yeah, he hasn't.
Yeah,
right.
So
Yeah.
we'll see what happens.
I mean,
now.
let's face it. Like,
Yeah. Right.
I mean, it
That's right.
might not be 25 years, but
You're innocent unless proven guilty, unless found guilty, right? I think this
Yeah.
guy's already been found guilty.
I think
Like,
he's.
I mean,
Yeah.
I don't like saying that. I don't like jumping to conclusions like that, especially with the legal system. But this one's gonna be hard for the defense attorney to win. I think that's why the defense was going so much at the old defense attorney. Like, why didn't you let him take this plea deal? Come on,
Right.
man, you're killing me. here.
Yeah.
yeah.
Paracord, thank you so much for the 15 months. I appreciate it, and good to see you. Good to see you as always. All right. Well, there's less than a minute left, and we pretty much heard everything that Judge Wolfe's about to say. So it's about that time to call it a night, ladies.
Ooh.
Aw.
I think we need
Yeah.
our flight attendant to tell us what to do.
That sure isn't me, Theresa.
No, I know. I needed to take a breath. My goodness. Okay. Attention, stream viewers. This is now the conclusion of our stream. We would like to take a moment to thank Colin for putting this wonderful stream together for us. A big thank you to all of our members. You are why Colin is able to continue streaming. To all viewers, whether live, lurking, or replay, we appreciate you. And for the very difficult job, we appreciate all of you wonderful mods. Please remember to gather all your belongings and return your keyboards to their upright and caps locked position. Please place all trash in the receptacles located at each exit. If you have not yet, please remember to hit the like on your way out. And as always, we thank you for flying Coolin' with Colin.
Thank you, Theresa. I appreciate it.
No problem.
Well, Jedi, thank you so much for hanging out. Theresa, thank you.
Yeah, thanks
Thank
for having
you
us.
for having us.
If I'm sure one of you will talk to Sparkle Poots before I see her, tell her thank you,
Yes.
and that I hope she feels better soon.
Yes, we will.
And yeah, with that, it looks like Lone Wolf's the only one streaming tonight, so I have it set up to raid him. Biggin, thanks again for the raid tonight. If you're still here, I'm gonna guess that you're not, but Biggin, thank you. I appreciate the raid. Everyone that came over from Biggins, thank you. All the membership milestones, the gifted memberships, the super chats. You guys are awesome. Mods, thank you so much. Thank you all for hanging out with me. And if you haven't done it already, hit that like button. It does help the channel. But that's it. That's all I got. I'll see you guys tomorrow. Until next time, bye.
Bye.
Okay, bye.
As any other defendant and he is presumed to be innocent, so we'll give him a trial date, and he may go to trial if he chooses to do so. The last thing is his request for a furlough, and based upon this court's opinion, it is not prudent to grant a furlough to Mr. Hollis prior to the finding of guilt or innocence in this case, based on his extensive criminal record. And I would point out that he was considered and then later rejected by the drug court. And I know Mr. Lockhart's familiar with that. He was rejected by as a participant in the 23rd Judicial Recovery Court, which in this court's opinion is another indication that a furlough while the case is pending would not be advisable. So both of these motions are respectfully denied. That concludes our business before court today. This court stands adjourned.
Thank you.